warm round of applause for Tom Franklin.
So I'm going to turbo through a few of these slides so that we can preserve a lot of time for questions and kind of interactively going through some of these situations at the end. So if you're really curious, catch me after a break or study the slides online. But I really want to get to the point where we're really talking about specific problems and working through those. And I think that's when you'll see, get a better understanding of how this works. So here's a slide. You know, today intellectual property is becoming a much larger fraction of what a company is about. You know, it used to be 30 years ago, 70% of your market cap could be tied back to physical assets. Today, the opposite is true. Really only about 30% of a company's value can be tied back to physical assets. So the remainder is these intangibles, you know, patents, copyrights, trademarks, goodwill. So it's becoming a much larger proportion of every business. And if you think about it, we're moving into this knowledge economy, this information age. And that's what kind of it's about. It's more about the information, controlling that knowledge is more about what a business is about rather than some factory somewhere. So every organization has kind of this amorphous cloud of intangibles. I did this for a particular client. But it's all that stuff that makes your organization successful. And it's a different cloud for every organization. And maybe we'll get into some specifics later. I have some kind of strategy examples, but really it's different for every business. So the key thing is to develop a strategy that's customized for your business. You know, look at what your competitors are doing. Intellectual property is a lot about creating barriers to entry and getting the most out of your investment in your company. So you got to look at your type of business, what the products are, the services, what the competitors are doing, how litigious the industry is, where you are in your funding cycle, what size of company you want, and what your growth strategy is. And then you develop a strategy. You know, with the wrong strategy, our services are very expensive. I think between me and Jeffrey, we're probably $1,000 an hour. For our clients. So it's very expensive per hour, so you got to get a laser focus on what you need to accomplish as inexpensively as possible, and where to spend the money and where not to spend the money. So intellectual property is all about taking these clouds of intellectual capital or intangibles, and putting them, I've drawn this figure as boxes, these different legal tools to protect that. So you have an idea, well, you don't own that idea until you, well, you may own it if you can protect it as a trade secret. You'll own it certainly if you file a patent on it and you get that patent. You have a product idea, a product name, well, you can enhance its value by filing a trademark on it. You created something, if it's suitable for copyright protection, you can enhance its value by just following a few simple rules. So I'm going to go through each of these tools very, very quickly. I'm going to spend about a half an hour doing it. And if your head is spinning a little bit, remember we're going to reserve a half an hour after Jeffrey's done and go back through and answer specific questions. So I start off at the cheap part, a trade secret. A trade secret is really anything that you can keep secret from your competition and has business value. So it's suitable for things that you can keep within the building, like a customer list would be a typical trade secret that every business is going to have. Who are your leads? Maybe where you get your parts from, where things are manufactured, how you put things together. Formulas within the building, how you manufacture something. But once it goes out into the wild, most anything can be reverse engineered, right? Every semiconductor chip, every chemical composition, every piece of software. So it becomes very, very difficult to control once it's gotten out in the wild. But in any event, it's very inexpensive. It's just a matter of keeping it secret within your organization, having some sort of plan where you recognize what is a trade secret and take proactive steps to protect it And then if it does get out into the wild, you have an employee that leaves and wants to take the customer list with them because they're going to start selling your competitor's product to the persons that they already have relationships with. You can send them a letter and say, hey, all well and good, but don't try calling up any of these people because you would have never known about it had you not been exposed to our trade secret. So you can do things like that to keep these kind of crown jewels protected. I'll go through some of the timing issues in a timeline exercise. So copyright is any artistic expression in a tangible form. So it's not me speaking, right? That's not tangible. But it is me on the tape, right? Or me recorded. Where it becomes real important for a lot of my clients is in software. Software coding, the way that a programmer decides to write code is treated as artistic expression. So it can be it's a very simple right. It protects against copying. It doesn't protect the functional aspects of it. So I can look at somebody's software and code it up from scratch. Won't have a copyright violation. But if I took a piece of that code, even a small insignificant piece of that code, and integrated it into my product, I would have a copyright violation. So it's a real simple thing a real simple way to avoid a problem is just not use other people's material and create things from scratch. But in every business, there'll be photographs you'll want to use in your advertising. There'll be music you might want to put on somewhere in your trade show booth or on your website or a picture or something like that. You just got to be very, very careful about not incorporating other people's material, and you should be fine. Where you get into problems is you may hire a programmer, you hire a consultant to come and do some programming for you. Well, who owns that code at the end of the day? Well, if you look at a lot of consultants' agreements, they would own the code and you just have the right to use it. You just got to make sure that when you're building up your business and you're dealing with third parties or people that have worked other places, they're not bringing that code with them or bringing any of that stuff with them or getting it off the internet. And you're going to be fine in most circumstances. It's a very easy thing to mess up, but a very simple thing to, if you're very careful about it, to not get in trouble with. So trademarks, every business has at least the name of the business, right? So every business has a trademark. So commonly what you can do is put a TM after whatever your trademark is, and maybe your products. So trademarks anything really that can be used to identify a source of one's products to consumers. So weird examples, NBC has that dun 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 that they play between, play all the time in their interstitial ads and stuff like that. Harley-Davidson tried to go after the sound of their mufflers. A bad muffler sometimes sounds like a Harley-Davidson muffler. So they weren't successful in that. But it'll be music, it'll be colors, for example. UPS has trademarked the color brown. So if you had designs on starting some sort of delivery service and having ruddy brown uniforms, forget about it. Jeep, the shape of their grill on the Jeep, they ran into problems because Hummer had a very similar grill. So they fought over that, and as it turns out, the government specified how the grill would look in both cases. So Jeep had to settle that. They weren't successful on the trademark front. But it's kind of what tells your consumers what your product is. So kind of with the last speaker we were going through, and it was the 30-second pitch. Well, especially when you're talking about lots of customers, you want to have something that's catchy and tells them it's your product very simply, right? Google has the word Google, but all the marks for their sub-products have that coloring scheme now with their lettering. So you could almost see a word that you wouldn't associate with Google, and if it has that coloring scheme where every character is a different color, you're going to perhaps think that that's a Google product. So you want something that kind of portrays your brand as simply as possible to consumers if you're talking about lots of consumers. So the more customers you have, the more important branding is. If you have, I have a client that has 2,000 customers and a potential of 10,000 customers. And they came to me saying, they're flush with cash, we want to file a trademark everywhere. And you can file these in almost every country on earth. But the cost, tremendously expensive. So, you know, they wanted to file in West Africa, right? And these countries that seem to change names every year. And although you can do it, I asked them how many potential customers you had in that country. 10, right? So what's the cost of sending those 10 people a nice gift basket with a new set of business cards, right? You know, it might cost $800. Well, to get a trademark in that country is $5,000, and then ongoing maintenance, right? So when you're talking about just a few customers, branding isn't such a big deal. But when you're talking about a lot of customers, especially unsophisticated customers, branding becomes very, very important. Patents, and we'll talk more and we'll delve more into patents, but I want to give everybody an overview. Every company wants to create barriers to entry. Every company wants to leverage and maximize the value of their intangibles. So you've got to kind of know the whole picture. Because for some people, as we were going around the room, there probably wasn't even a patent play. But it may be branding. I don't know on the chin exerciser. There is a patent, yeah. But you know, there you're talking about a lot of consumers, and it might be a catchy name, right?
It's chin up and it's trademarked.
There you go. So that could, in the end, be much more valuable than the patent. The patent will expire. Trademarks don't, so long as you're using them. So when you're talking about consumer goods, at some point, everybody's going to go to the store saying, I want a chin-up, right? And they're not going to be so concerned about the patent. And there may be somebody else selling a different product there, but, you know, people want the chin-up. I want to get the thing that I know works, right? So really developing that relationship with your consumers can often eclipse the value of a patent. So a patent confers an inventor the right to exclude others from making or really doing anything with your invention. So it's an exclusionary right, which is kind of the key thing. It's not a right to do it. That you have a patent or have applied for a patent on a chin-up doesn't mean that somebody else doesn't have a patent out there that you would infringe. It just means that if somebody uses your innovation or maybe your tweak on the idea, you can stop them from using that tweak. So the example I use is, say somebody invented an automobile, body with 4 wheels, right? And they came out with this, I guess it was probably in caveman times, but they had stone wheels, right? And they found that these automobiles went about 4 blocks before the stone wheels fell apart. And then you come up with a tire, right? And this example isn't too far from the truth. When they had the wagon wheel, right? I think they had to change a tire or repair the wheels about once a week, right? They just didn't last that long. So someone comes out with a better wheel. The person that has the wheel cannot sell automobiles. And the person that sells automobiles can't sell an automobile that anybody will buy because they only go 4 blocks. So what happens in a circumstance like that is you might come to an agreement, you might agree to cross-license so that you both can sell automobiles with wheels that'll not break down every 4 blocks or a couple times a week. Really anything that's made by man can be patented. So software, business methods in certain circumstances. But really any sort of technological thing, there's probably a way to go after some sort of patent right. And there's a wide variety of patent rights. Every country has 3 or 4 variations. And I think Jeffrey will get into some of the variations in China later. So I'm going to go through this timeline a little bit just to kind of walk through, and this is perhaps for designed for a larger company. But let me explain a little bit. You read this right to left like you would read a sentence on a page. And on top is what the company is doing, and on bottom is what I would be counseling. the client to do. So if everybody understands it, I'll kind of just start in the upper left corner there. Begin. So you might want to move into a no product area. Often it's not this deliberate, right? But it is deliberate with some big companies. So you might do a patent landscape study to find out what's going on in that space. Some areas are just rife with patents. I have a couple clients that are in the smart card area. Credit cards now have smart cards. Passes for transit have smart cards. But at any rate, there's just so many patents that would make your head spin. So you want to find out what you're getting into if it's a completely new product area, because there are some areas that would be very difficult to go into without having a very large patent portfolio, and that may suggest if you really want to go into that space, you start early and start building up a bigger portfolio. But say you go into an area and you think there's some ability to innovate and not be tromping on other people's rights too much. So you go in there and you actually come up with the actual product, you invent your product or service. And then once you know what it is, you might have started up, I'm going to pick on you today, but you might have started out thinking I'm going to come out with some sort of health aid or exercise thing, right? So you start looking at what's out there, and there seems to be plenty of room to come up with some new innovation. It's an area where a lot of people come out of product and patent it and make a lot of money. So you come up with the chin-up, right? You come out with the chin-up. Well, then you go and look to see if anybody has a patent on exactly the way that you've designed the chin-up, right? And what you might find is there are actually patents out there. Should there be patents out there, you might be able to avoid them. But you certainly want to make sure that you're not buying a lawsuit by coming out with this product. So you would do this clearance study. So once you kind of find out that the idea generally is not patented, you might finalize the design, begin the design. But at any rate, you got to figure out how to manufacture in that. And as you start doing that, you're going to come up with your own innovations, things that you could patent, so you might consider them at that point. Some point in the process, people are going to start coming up with names. Just as a practical matter, you have to call the widget something, right? So a name comes early in the process. And when it comes, it might be a code name. Some of my big clients always have these code names, right? So when you have this code name, first thing you want to do is you want to start buying the domain names for them. What often happens is the first time you do a press release with the product name and you haven't bought the domain name, somebody else buys it that day. So there's people that are scouring websites and trying to find out what product names might be kind of these cyber squatters. So domain names are very inexpensive. So really early in the process, before you get too wed to a particular name, make sure that you can actually own that domain name, especially if it's a consumer product where getting information online is going to be real important. So if you're wed to that name, you can own the domain name. It's short and catchy, and I always tell people the more consumers you have, the smaller the domain name has to be, right? So you get people that will have 3 words, it'd be a long thing. It's rife for misspellings, and every misspelling is going to be picked up if it's a popular product by a cyber squatter again. That's going to be selling something probably that you don't want to be sold under your name, either a competitor's product in the best case or something unsavory in the worst case. So coming up with a very, very short name is real important if you have a lot of consumers. If you don't have a lot of consumers, no big deal. If they're very sophisticated purchasers, no big deal. They're going to be able to figure out how to find your product, right? So one thing when you're coming out with a name for a product or a name for your business, you want to make sure that, again, you're not tromping on somebody's rights. So you can do a trademark search. And clients will ask me, it's almost the same cost as of doing a trademark search is almost as costly as filing a trademark. So some would say, well, why not do it? We'll file it, let the trademark office figure out if we're entitled to that trademark. The cost of doing it wrong is the cost of changing your name, right? So if I come out with a product today and pick a name, and I have to change my name tomorrow, what does it cost me? Nothing. Well, I've told 40 people, maybe 50 people, what the idea is. I'd have to email you guys and say, no, 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 it's not the chin sizer, it's the chin up today. Not a big deal, but say I invest, well, my trademark is pending, I invest a lot of money in advertising this, right? Or say I get 5 years down the line and this person really does come out of the woodwork. There's a big company out there that's litigious. It's just a matter of time before I get that letter. Well, I'm going to have to change my name at that point and think of all the goodwill that I've invested in a name that I can no longer use. So in the worst case example, we had this client, they were making a PDA, and as it turned out, a large Japanese company came out with a PDA that it wasn't the same name. There was one letter that was different. And my client's PDA wasn't selling. It was back when Apple had their Newton, right? And everybody thought tablets would be a big thing, and they never were really a big thing. Well, this Japanese company ended up buying my client to get out of that trademark problem. And it was something that a $1,200 search would have fixed, right? So can be real important. So at some point you start interacting with people. And that's where it gets a little dicey, right? Everybody believes that there's some boogeyman out there, there's some stranger that's going around and ripping off ideas from people. And it's really the farthest thing from the truth. The people that are going to rip off your ideas are the people, they're your partners, they're the vendors you want to for help. They're much more likely to be somebody that knows you rather than somebody that doesn't know you. So when you start interacting with these people, you've got to make sure that they're at least willing to keep your ideas secret. And some people will not. Some people will not sign non-disclosure agreements or confidentiality agreements. But really, at some point, almost every business has to start interacting with people. You know, if you're tooling up for something, you have to talk to somebody who can produce this thing. You might have to go out overseas to somebody that might be manufacturing it overseas. Well, potentially each one of those people, they're talking to you, but you know, they have a manufacturing line, for example. And if you tell them an idea and there's no confidentiality agreement, there's no trade secret there, and you have no patent, it's not stealing for them to take it. It's just good business in some sense, right? It doesn't seem morally right, but legally there's no problem with it. So when you have to go out and talk to these people, if you haven't protected your rights otherwise, you want to make sure that they're going to not steal those ideas from you. So at some point you have to start then thinking about patents, right? Sometimes people will do it even before they start talking to partners. That's probably a safer way to do it. Then you don't have to worry about non-disclosures so much. A non-disclosure agreement is just an agreement, right? It's just a contract. And your remedy is to sue under the contract, right? So you might talk to somebody that you know you want to bring in as a consultant, right? And they talk to you, maybe they even sign the agreement, and they're like, agreement, we sign those, we don't even pay attention to those, and they blog about it the next day, right? And you had planned on filing a patent on it, right? Well, they may affect certainly your overseas patent rights by blogging about it. And then, you know, you can go and sue that person. Maybe they have a little bit of equity in their house. Probably legal fees are going to be much more than any money you could get from them. So contracts are only as good as a contract is, right? So a patent gives you a broader ability to protect that idea. So even if they blogged about it and somebody read the blog, started developing a similar product, you always have a backup plan, and that you can use that patent or assert that patent to slow them down or stop them. So the next kind of big thing is public marketing begins. So before you talk about it, file your patents, file your trademark applications. You already have your domains purchased, one would hope at this point. And then at some point you finalize design, or often it's iterative in the real world. So you're going to be filing more patents as you come up with things. You might find that the way you thought you were going to manufacture the chin-up didn't quite work. There was a way to produce it for half the cost, right? And there's this little innovation. Well, that's suitable for patenting too, right? If you, at the end of the day, can produce it for half the cost of the other person, that's a big marketing advantage if they don't have that. If there is any artistic expression, so software, sometimes brochures or marketing material, maybe. I think you're just better off putting a notice on some of those things, copyright notice. But you would want to file your copyrights before the product is sold. Really, nobody can copy your stuff until they have it, right? So that's kind of the trigger for filing your copyrights. And then, $, you're making some money, hopefully, right? And as you start to make money, success breeds competition. You're going to have people that are going to want to rip you off, right? So policing for people that might be infringing, and at that point you might consider some litigation. Or, the threat of litigation. But at any rate, what you've done is you want to create these barriers to entry. Well, sometimes people have to be reminded about these barriers, right? And sometimes those reminders are just a letter or just a phone call, and sometimes it's a lawsuit, right? Depending on the dollars involved. And then, you're going to improve the product, you're going to file patents on the improvement, you might file some other intellectual property for some other intellectual property, and you're going to make more money. And then you're going to come up with a new product, and you're going to repeat this cycle. And this is somewhat generalized. It isn't a great timeline for everybody. So kind of briefly before I run out of time, I'm going to go through a slide or two and talk about some of the situations. But my hope is that in the remaining half an hour after we're done up here, we can really dive in and talk about specific examples. Because the key when I started out was, it's expensive to deal with IP attorneys. We tend to be 50% or 100% more expensive than just an average attorney. So the key is coming up with a strategy that's focused and can, for the least amount of money possible, get you those barriers that you're going to need or get you that funding that you're going to need, right? So knowing kind of what your end strategy is and knowing what those investors might be interested in. What's your end strategy? You're going to get acquired. Well, who are you going to get acquired by? Well, what do they like their patent portfolio to look like? Do they care about your brands? Probably not. They're going to change the name of your company, right? So thinking about where you should be spending money because it always is a finite resource. So the key thing that I always look at is I always do a market-driven approach to IP. So I want to look at what's selling your product, right? And often, like when we were doing, I think of them as elevator pitches that we were doing earlier, right? But I could take those and work backward from that to find out what your crown jewels are. And some things you can protect, some things you can't. Some things stay in the cloud, and we can't put them in a box, right? But to the extent that we can put them in a box and enhance the value of that cloud, that amorphous group of intangibles, your intellectual capital, that's what I'm paid to do, right? So someone will come to me and say, we're 10% faster. Clean stains 20% better. Well, what do you mean? Why are you faster, right? Well, we're faster because we did X, Y, and Z, or we cut out this step, or we... so let's file a patent on cutting out that step, right? So you could almost start with the marketing material and figure out where you're going to spend your budget, right? It's a limited budget. But if the marketing people are hitting on the same points that you have protected, that's your IP is exactly aligned with what your business strategy is probably at any given moment. So that's why I start with the market. Because if you can go in there and all your salespeople are saying, well, gosh, it clean stains 20% better. Well, your competitors are going to immediately try and clean their stains 20% better, right? Well, there's a cold water enzyme that we use, and that's what does it, and we're the only people that use these. And we filed patents on these cold water enzymes, right? So we can make the claim that's 20% better, and our competitors are stuck. They've got a roadblock. They've got something that doesn't clean stains very well, in cold water at least, right? So come up with a budget. You know, I can design a budget of any size almost. There are limits on the low end of what you can do, right? But sometimes you can kind of cut some corners to get going to your next round of funding so that things can be cleaned up at that time. And that's the impetus. You know, we've started this patent portfolio and everything looks great, but you know, with your dollars, investor, we're going to go in there and we're going to get a portfolio looking the way that you want it to look. So key thing too is always be reevaluating. You know, you'll file patents. You may have filed in a bunch of foreign jurisdictions. Well, you got to constantly reevaluate whether that makes sense or not. And sometimes you have to abandon things, right? It's not just the filing of the patents or the trademarks, the copyrights. It's maintaining them over time, doing the arguing back and forth, right? And there's sunk costs. You know, I have clients, especially in this economy, they're abandoning their portfolio, their patent portfolio in droves, and we're getting down to the core stuff, and we're refocusing, right? And their strategy has changed, right? And there's strategies to do that. So you always got to be looking at this because these expenses can grow over time. So I have some examples in here. They're in your materials. You might look at the slide that seems closest to your business. I talk about startups. I talk about what universities think about when they're talking about IP. Big business, pharma, stuff like that. You can look through those examples, but I think it's really best to sit down and talk to somebody like me or Jeffrey and get kind of just a 50-cent read on kind of what's relevant to your business. And we'll try and do that if we reserve enough time. So with that, I think I'll stop and turn it over to Jeffrey.
With that, let's give a warm round of applause to Jeffrey.
Oh, thank you. Thank you. Now, just real quick, thank you all for having me here, speaking with you. What Mike said is completely true. I think it was a good introduction to the intellectual property rights that are available to you in early phase and in startup phase. What I'm going to focus on in this talk is patent practice in China and some examples there, especially in comparison to U.S. practice. But one thing I wanted to also mention in terms of, I guess, two highlights to take away from the talk, if you can remember it, is with a limited budget in China, the two most things you should be conscious of is filing a trademark there, and if you have mechanical products, filing utility model patents there. And I'll explain a little bit what the utility model patent is there. But those two things are probably the biggest bang for your buck. Your trademark will cost you about $1,000 per trademark that you file there. Utility model will cost you less than half of what a normal patent would cost you, and it comes out in about a year. All right. So those two things is if you have a limited budget and China is somewhere in your plans, whether it's you plan someday to hopefully sell there, you think you're going to be acquired by someone, or you might have an exit strategy to sell to a corporation that has China plans, or you plan to manufacture there, which at the end of the day, most companies, when they get to a larger size, all of those things apply. Then you should be considering those two things, all right? Especially in the trademark area, since I don't have any slides on it, this presentation about, but we do a lot in trademark area, you see a lot of trademark hijacking going on. Once you get a little bit more success in your product, there are Chinese companies, there are Chinese competitors that look around, they look at trade magazines, they go to trade shows, they go, oh, that's a really interesting product. And you know, and then they'll check, they'll do their own clearance search in China and be like, oh, they didn't file for a trademark in China. That's a good name, it's better than my name, I don't have a name. I'm just going to file that trademark, right? And it happens every day. Right? China is the first to file system, both in patents and trademarks. Trying to get that back later on is very difficult. So if you have it in your plan, if you've gotten to that part of your life cycle, seriously consider filing those trademarks. And as for utility model patents, I'll get into that. All right, just an overview of what I'll be talking about. First, I'll be talking about filing practice and some differences with the United States. And then I'll go into utility model patents, which was a highlight I wanted to share with you. I'll introduce patent invalidation in China very briefly, patent litigation very briefly in China, and then I'll go to a case study. There's a very interesting case called the Schneider Electric case, where actually a French company, a very large company, Fortune 500 conglomerate, is a very strong innovator in the circuit breaker technology. And they brought in circuit breakers into China in the early 90s. And they had a lot of competition copying them. Now, one of their competition at the time, they thought in around 97, I'm going to file a utility model patent to cover that circuit breaker. In 2007, they sued Schneider on that patent, and a local court in China awarded about 48 million US dollars in damages. All right, which was the largest amount of IP damages in China, and still is today. And we acted for Schneider on the appellate case, but that case study will bring together a lot of the things I'll talk about. Okay, filing practice. One thing to consider is, are you going to, is it necessary to file patents to protect your innovations, your inventions? If you're going to go in that direction, then in China, clearly, before you can do anything to stop someone from copying you in that space, you need to have a patent. So you need to consider when you're going to file. All right. Now, in the United States, you have some grace periods. You have a 1-year grace period. In China, you don't. All right. So if in the United States you publish something, you go to a trade show, you hand out some flyers, you didn't file in China, you don't have the ability to file anymore. Or your patent, you could file it, but your patent would be invalid. All right. So think about that. If there's intrinsic value there, file your patents in China. Now, secondarily, also anti-hijacking. And it happens in China, it really does, and so it's something to be conscious of, is you need to be conscious of filing some of these patents also to get them online and get them in registration so that a Chinese competitor or a competitor of yours, if you're manufacturing in China, doesn't go and file something covering your technology. All right? Now, Chinese patent examination is getting better, it's getting more sophisticated. The examiners are getting more experience. That said, it's generally not as robust as US examination or European examination. And the result of that is sometimes you get broader patents coming out in China that you do in the United States or in Europe. But just be conscious of that to harmonize that. Now, the question was, from the floor, was that I was under the impression that my US patent is only good in the United States, but I may have implied that the US patent will keep filing of a China patent. That was the question. Right. Now, that wasn't my point. My point was that if you were to publish something in the United States, let's say go to a trade show and hand out flyers, that's what's going to prevent you from filing a patent in China. Right. But your US patent itself, because it's an application that's meant to be kept secret, that won't affect someone else from filing in China until something publishes, something is in the public domain. All right. So in your case, if you file a US patent, it has no effect on China until that US patent publishes, which is usually about in 18 months. All right. Okay, moving on. So the point too that I wanted to make was that if you are going to file in China and you file in the United States, just make sure that you harmonize your patents. Right? Just because you can get a broader patent in China because, let's say, maybe the examination isn't as robust, doesn't mean you should. Because when it comes time to enforce it, then your competitor or your defendant is going to go look at your US patent, is going to go look at that record, and they're going to say, well, in the United States you had to change it because there was this prior technology. And in China you may not have had to, and they're still going to go ahead and invalidate your patent. All right? Third point is consider filing. You can actually file at the same date a utility model patent, which is a junior patent, and an invention patent, which is a full patent. So consider that. And then finally, patent clearances, something talked about previously, something that's worthwhile in doing just to make sure what the space is like. You can file submissions and some other points I'll discuss. Right. Now, just generally, I mean, your patent portfolios is just, it's both good from a defensive standpoint as well as adding value to whatever product portfolio you're selling. The exit strategy I just mentioned briefly is that most large corporations, they're thinking about cost savings manufacturing in China for scale. And, you know, they'll be conscious of, well, what do you have? You know, what can I do if this does take off? Do I have any protection in China? And the answer could be, if you went to a trade show, passed out some flyers, you didn't find anything in China, well, actually, I don't have anything. So if someone took that same idea and started manufacturing it in terms of patents, you have no protection. So it's something to consider when you're considering your budgets and your expenditures. Examination criteria, I'm not going to go too far into this. The slides will be online. I think I just gave them to DaVinci today, so I guess I'll put them up later. But just for those who understand patents, very similar to the United States, the standards. The main difference is right now, the law recently changed that prior technology used to be only worldwide publications, right? Like something like article, another patent, right? But only sales or knowledge in China, right? But now they've changed that as of October 1st to worldwide. So if you go to a trade show and you express, you share your idea with someone, and that's documented, somehow someone can attest to that, that could still invalidate your patent in China, right? And then the no 1 year grace period. Again, in the United States, you generally have 1 year grace period of public disclosure to file, but in China you don't, right? So just be conscious of that. These numbers are a little bit dated. The main point was trying to get across, harmonize your patents, make sure that if you have strong prior art in the United States or strong prior technology you know of and you have to narrow your patent a bit, that you consider doing that in China as well. Don't just let a patent in China come through because you could. And one of the two reasons why there may be that difference in China and the United States is that the bottom two bullet points, there's no best mode requirement strictly enforced in China, which means in the United States you're required to put your best example of your technology in your patent. Okay? In China you don't have to. And then the second one, in the United States you have to actually disclose, the duty of candor is the best prior technology you know that's closest to your technology. In China you don't. Right? So oftentimes you have patents go through and there's very little that the examiner has given to him to compare with, right? And he might say, okay, well then that's inventive because I just didn't know about it, right? Whereas in the United States, you actually have to go give that. If you said, okay, well, I differ from this prior product by a little bit, and I have to give you that reference. In China, you don't, right? So for that reason, the result is sometimes you can get broader patents in China, but the suggestion is that you don't, right? Be conscious of that because we've dealt with a lot of litigation, and when it comes time to enforce it, you're like, great, I have this thing that's really broad, but I can't use it because it's invalid, right? The other point from this slide is Chinese claims. If you're going to, when you file your patent in China, oftentimes you can come into translation issues. The Chinese patent agent there just translates it and submits it, right? And you have to harmonize your claims, which cover what emabodyes your invention, with your description of trying to teach that invention. There has to be a correspondence. Whereas oftentimes in your emails to foreign agents, they translate something differently, and then no longer does it have correspondence back to the teaching of your patent specification. Right. So it's a little bit, that's a very specific situation, but we've seen it happen. So just be conscious of when you are prosecuting your patents in China, they're pretty strict on making sure your claims match your patent specification, right, or the terms match. Okay, let me get on to utility models. This is a little bit more tangible. This is something I did want to share with everyone here, especially if you have like a mechanical invention. I heard earlier there's at least 2 individuals in here, or multiples, that are talking about mechanical-based inventions. There is something open to you which we don't have in the United States called utility model patents, which is in comparison to invention patents in China. Now, the utility model patent is only meant to cover the shape and the structure and the mechanical nature of a product, and not the chemical nature or the method of doing something. So in this slide, for instance, if you have a new bicycle or a new wheel, then yes, you can get a utility model patent. But if you have a new butter alternative, you couldn't get a utility model patent. Okay. Now the differences. The main difference is, again, first one is subject matter. The second one is the test for inventiveness is lower. What that means is it's actually, strangely enough, harder to invalidate a utility model patent. Right? Now the other point is it's not examined. You file it and it grants. Right? It usually only takes about 1 year to come out, as opposed to about 4 years to come out for an invention patent. The trade-off is it has 10 years of life versus 20 years of life. So it depends on, if you're a pharma company, this is not really going to help you, right? But if you're coming out with a product that changes very quickly, it's going to help you. The other ability you have is you can file on the same date a utility model patent and an invention patent in China. Right? So your utility model patent comes out after a year. If you get your patent granted, let's say in 4 years, you then abandon your utility model patent and use the protection of the invention patent. Okay? So I really encourage, if what you're going to be doing in China is at least get some utility model patents online if you're doing mechanical patents, mechanical products. Now the last point in there, and I'll go into litigation a bit, is in China, unlike the United States, a court can decide when there's a patent infringement litigation is there infringement and is the patent valid? Right? Or probably the first one first, is the patent valid? And if so, is it infringed? Right? In China, it's actually separated or bifurcated. The court system hears whether it's infringed, and an administrative system hears whether the patent is invalid. Okay? And because of those two systems, sometimes the defendant is going to say, look, court, you need to stay this infringement case because I'm trying to invalidate the patent. Right? And the general rule is that utility model patents, when it comes time to litigate, that infringement case will be stayed, but it's a case-by-case basis. Right? Okay, so the filing strategy that I mentioned, really dual filing. I mean, we can't recommend this more highly, both for early stage, late stage, large corporations. If you have a mechanical product, file the utility model patents. They come online. They're actually harder to invalidate. In our case study, we'll see that it was actually a utility model patent that was used. And therefore, get them online. They're not expensive to put online. They come out in a year, right? And you have the patent grants. And from a marketing perspective, you can say, you don't even have to say patent pending. You have a patent in China, 9 months to 12 months. Right? So it's right there. And also, just as a data point, the largest number of utility model patents are filed by Chinese corporations. By and large, they file utility model patents. A lot of people think of them as junk patents because they're not examined. A lot of them are invalid because of that reason. But it still exists, and your competitor will have to invalidate it, or if you're there and your competitor files one, you're going to have to invalidate theirs. Right? Okay. Defensive strategies. This is something that was talked about briefly, but just clearance searches. Try to find out what's out there, especially if you're manufacturing in China or you're selling in China. You want to see what else, what other patents are out there. Invalidate patents which you consider a risk to your product, and build your own patent portfolio. Discussed this already, I'll move on. One particular risk is the utility model patents because of their prevalence in China, is to be conscious of. In the case study, that's exactly what happened. You had a Chinese party. They took a product that was introduced into China. They took it apart. They reverse engineered it, and they patented it. They filed a utility model patent on it. So be conscious of your competitors might be doing that as well. Or if you go to China and you use a manufacturer or distributor, they might be doing that as well. So be conscious of what's coming out so you can know, okay, well, do I need to go and invalidate that before it becomes a problem? In China, you have the right to, if you see a patent published similar to the United States, you file it, it publishes, and then after a period of time, it either is granted or not by the U.S. Patent Office. In China as well, the Chinese Patent Office, you file it, it publishes, and then there's a period of about another 2.5 years before it grants. In that period, sometimes you'll say, hey, look, that application is invalid. It covers my product, right? And I know I filed my patent, or there was some publications I had on this product before the Chinese company filed it. Well, what you can do is you can make a submission to the Patent Office regarding that application, and submit what you've seen before. Or you might see it blatantly covering what was already known, that's very general, and will cover your product. Even though your product is improvement, it's just so broad. And we've done that before. So it's something to consider, especially because on the last point, since there's no duty for the applicant themselves to submit even something that's blatantly similar, then sometimes it's worthwhile to just make that submission. All right, these are just some miscellaneous. A new change that also came effective October 1st is that if you're collaborating, let's say, with a Chinese inventor, or let's say you have a Chinese manufacturer and they talk to you and they're like, okay, we can make this, and they have a eureka moment. They say, well, actually, why don't you do this? This will actually save you some time and money, and it's great, and you incorporate it. If you do that, then you need to be conscious of, the previous rule is that if you wanted to go and say, okay, let's file a patent jointly on that. I have my stuff, you have your stuff, let's file a patent in the United States on that. In the past, you had to file that first in China, right? Now you have to go through something called confidentiality examination. You just have to make an application to the Chinese patent office, and they consider, well, as long as this doesn't deal with encryption or military technology or whatnot, then you can go file it wherever you want. But it's just something you need to do. But don't just take that and just go run to the U.S. Patent Office and file it, right? Because then your Chinese patent will be invalid. Well, divisional patents, this is something really particular to patent practice. I could talk to you more about it in question and answer. Invalidation of patents, really quick. As I mentioned, it's bifurcated. So you have the courts here, infringement. You have the administrative bodies, which is called the Patent Review Board here, invalidations. One other thing in China is there's no post-grant amendment. So once your patent comes out, it is what it is. Even if you made some errors on it, you can't go back and change it. Right? In the United States, you do have some leeway to go back and have changes made. Both for infringement cases and invalidation cases, cases are difficult in China because the courts and the administrative boards put the burden on the plaintiff. It's almost like a criminal case. If you think about it as a criminal case in the United States, to win a case in China, you have to bring your own evidence. You have to bring it to a very high burden. Right? Whereas in the United States, it's like 50-50. If you can convince the court greater than 50% chance on your side, then, which is the preponderance of the evidence standard, then you should win. Okay? There's no discovery. In the United States, you actually have discovery mechanisms that help you go, and let's say you have an infringer in China, and if it was in the United States, you could say, show me your records, show me your design records, show me your sales records. In China, you don't have that. You need to go and get that evidence yourself. Okay? Let's move on. Invalidations are heard by the patent board sitting in Beijing, and they're pretty good. They hear many of these cases. You have 2 levels of appeal after that. Invalidation, the grounds, the substantive grounds, are very similar to the United States, so I won't go into that. The procedure, the main point I want to come out of this slide is it's pretty quick. You usually will get an invalidation decision within about a year and a half. And then you have your appeals take about a half year to a year, right? Which is pretty quick. So it's something to consider if you need to do, that it can be done fairly straightforward before a professional board. Okay, a short introduction to litigation, then we'll go into the case study. There are no jury trials in China. It's a panel of 3 judges that hear your case. Again, just the bifurcation point. Again, the burden of proof is very high, and most of the cases are heard based on documents, not on testimony. Testimony is highly discounted, and often, actually, it's very rare to actually see testimony given in court. There's no discovery, so you have to consider where you can get your evidence that your competitor or your counterfeiter is infringing you. And we've worked with many different ways to gather that evidence, but that's really just the point there. Claim construction and proof. This is, again, more for patent litigators or patent practice. In the United States, you have a separate hearing to try to, the judge decides, well, what does those claims mean? What does your patent mean? In China, it's all heard in the same hearing. Let me move on. All right, forum shopping. This is another take-home point, again, along with trademarking, your filing trademarks, utility models. If you ever get into an action in China, you really have to be conscious of where that action is. All right? There is still a lot of local protectionism in China and corruption in certain smaller courts. But the bigger courts generally are more removed from that and also have better experience hearing cases. Now, this picture right here was a picture of a judge that would travel around China and, set up his own, he could hear cases. And it's similar to the history of the United States. You'd have circuit judges that would travel around back when there weren't too many courts set up. Now, and unfortunately, I'm sure you like the guy, you're probably going to get him to come sit down and hear your case, but the point is, be conscious of that. If you get into a dispute in China, where is the case filed? Okay. Let me move on just real quickly to the case study. I think it'll be more interesting. This is just a picture of a courtroom in China. All right. You have 3 judges. You have a court reporter. Court reporter doesn't take verbatim of the trial or the hearings, but takes a court record. Expert evidence and testing evidence is used and accepted. Let me move on to the case study. Okay. Now, Schneider Electric case. Let me get to the slide with the picture of the product. Okay. Now, basic background on this case. Schneider Electric makes a number of electrical products, one of which is miniature circuit breakers you'll see in apartments and many houses. Right? They made the product on the left. Their Chinese competitor filed a patent for it in 1997. The Schneider company also had a patent that predated the Chinese competitor patent, and if you look at them side by side, they're actually very, very close. Okay. Now, let me move back up to the introduction to it. The main take-home I want to bring to bear here is that in this case, it was the largest damages in Chinese history for all intellectual property cases, and it was for a utility model patent. All right, so there's more value in utility model patents than a lot of people give credit for. This is just a graph of actually the largest cases, damage awards in China. Generally, damage awards in China are low, but if you'll see the Schneider case is by far much larger by orders of magnitude than most other cases. And this was also a case, it brings to bear the knowledge of your venue selection. This case was heard in Wenzhou, which is a small Chinese city in Zhejiang province, where the Chinese manufacturer Qin is their home base. And the head of Qin is a sitting member of the National People's Congress, which you could think of as almost like a local congressman. Well, a national congressman, but he was sitting in this city. There definitely was local protectionism in this case, and the result was a massive damage award for a patent which was about 5 pages long, probably cost them about maybe $1,000 to file. So with my 2 minutes, I'm just going to go to the take-homes for that. Utility models are being used aggressively in China. So even if you manufacture in China or you're going to sell and manufacture in China, there's a good chance that a utility model may be asserted against you. So from a defensive standpoint, it makes sense to monitor your local competition. Evidence in this case, Schneider was not able to invalidate that Chinese patent, even though it was very similar. And that's also because of what I discussed. You need to keep original documents. If you're inventing things, keep original documents. If you're selling them, keep original documents. That's what you need if you get into a dispute in China. Forum shopping. In China, you have the ability to file for, in a court, to say that I don't infringe someone's patent. So in this case, Schneider could have went to Beijing and said, you know, I want you to hear the case and make a decision whether I infringe the patent of Qin, right? And the court would have heard that case, and that case would have been outside of Wenzhou. But instead, the Chinese competitor got in there early and then sued them in their locality to their great benefit. So that's something to consider in your forum. You can also file for these declarations. Now, the other proactive thing for people in early stage, consider filing utility models. I wanted to really go through that case study to bring home the point that they have value, they are cheap, you can dual file, right? If you do have plans to have this as a longer life, 20-year life, but you want to get something quickly, file at the same time you file the invention patent. They're cheap, they're quick, they have value. And that's all I have. Thank you.